Hello friends, welcome to my YouTube channel Judgment Day. ನಮಸ್ಕಾರ ಸ್ನೇಹಿತರೆ, ತಮ್ಮೆಲ್ಲರಿಗೂ ನನ್ನ ಯೂಟ್ಯೂಬ್ ವಾಹಿನಿ ಜಡ್ಜ್ಮೆಂಟ್ ಡೇಗೆ ಸ್ವಾಗತ. Friends, today we will see a case wherein Honorable Supreme Court decided that once a dispute regarding title is settled, permanent injunction cannot be granted against true owner. This is a civil case. This is regarding property title. Let's see the details below, friends. What the Honorable Court held was, once a suit is held to be not maintainable, so no relief of injunction can be granted. Here, an injunction cannot be granted against a true owner. The owner he himself, the person who is in unlawful possession, as of now we have seen, as of now unlawful possession cannot get any injunction, permanent injunction against the rightful owner or title holder and in favor of a trespasser or a person in unlawful possession. That is what. Whenever any property is in particular owner's name, when he is the legal owner, established legal owner, the other person will become trespasser. The case title is Padhiyar, Prahladji, Chenaji, deceased. Deceased means he is no more, versus Maniben, Jagmalbhai, Maniben, Jagmalbhai. She is also deceased. Deceased means both are no more. Hope the respondents as well as plaintiff and respondents both are here represented by their legal representatives. The Honorable Court held that once the dispute with respect to title is settled and it is held against the plaintiff, in that case, the suit by the plaintiff for permanent injunction shall not be maintainable against the true owner. Here, plaintiff is not the true owner. In such a situation, it will not be open for the plaintiff to contend that though he or she has lost the case so far as the title dispute is concerned, the defendant, the true owner, still be restrained from disturbing his or her possession and his or her possession be protected. That is what said. One cannot bring a permanent injunction after the title is settled in favor of the rightful owner or the original owner. Bench added that injunction is a consequential relief, and in a suit for declaration with a consequential relief of injunction, it is not a suit for declaration simpliciter. It is a suit for declaration with a further relief. That is what it said. And also, it opined that injunction may be granted even against the true owner of the property only when the person seeking the relief is in lawful possession and enjoyment of the property, and also legally entitled to be in possession, not to dispossess him, except in due process of law. So the details is the original plaintiff had claimed that to avoid the financial mess created by her husband drinking problem, she sold 1 gunta of her own 6 guntas of land to the defendant. 1 gunta is the measure of a land wherein 1 acre of land will be consisting of 40 guntas. So 1 gunta is 33 feet by 33 feet. So out of 6 guntas what she is holding, she sold off 1 gunta to the plaintiff here. However, the defendant allegedly played fraud upon her and prepared a deed to sell all 6 guntas. The defendant claimed to be the true owner and cited revenue records which had mutated his name since 1976 and that he was even cultivating in the land. So this is a case of changed mutation. The data has been wrongfully changed into that person's name, the person who is in illegal possession. The plaintiff thereafter challenged the same and sought the cancellation of the sale deed, return of the 1 gunta land, and a permanent injunction against the defendant. So out of 6 guntas, she sold 1 gunta for one. So remaining 5 guntas has to be in her name only. But unfortunately, that has been transferred to the person who has purchased the 1 gunta of land. And she sought the cancellation of the sale deed. That means she is not selling anything at all. 1 gunta which was sold, she is asking to return that 1 gunta land as well, and a permanent injunction against the defendant as he did some fraud. Trial court held that the sale deed to be valid and that it was in favor of the defendant. However, it granted permanent injunction against the defendant on the 5 guntas of land stating that the plaintiff was in possession of the same. See here. He sold one gunta, but unfortunately, 5 gunta, all the 6 guntas has gone into the purchaser, and in turn, the purchaser is the defendant who brought a permanent injunction against the owner itself, original owner itself. On appeal, Gujarat High Court held that a suit for validity of sale deed to have attained finality and barred by limitation, but held that permanent injunction would still lie against the defendant. Here, the original owner is in trouble here. Finally, the defendant is nothing but the original owner, appealed against the same in Supreme Court. The top court held that once the defendant was held to be the true and absolute owner pursuant to the registered sale deed executed in his favor, and the plaintiff was unsuccessful so far as the declaratory relief is concerned. Here, uh, uh, declaratory relief is concerned, it cannot be said that there was a cloud over the title of the plaintiff or even the defendant. So, here, the defendant itself, defendant is the original owner, that lady, and the plaintiff. So, plaintiff was unsuccessful because he had done fraud in converting the documents to his name through the mutation changes. High Court has not properly appreciated the distinction between a substantive relief and a consequential relief. The High Court has observed that in the instant case, the relief of permanent injunction can be said to be a substantive relief, permanent injunction, which is clearly an erroneous view. It cannot give. Supreme Court further held that once the suit is held to be barred by limitation with respect to the declaratory relief, and when the relief of permanent injunction was a consequential relief. See this, respect to declaratory. See, suit is held to be barred by limitation with respect to the declaratory relief, and when the relief for permanent injunction was a consequential relief, the prayer for permanent injunction, which was a consequential relief, can also said to be barred by limitation. So, permanent injunction can said to be a substantive relief. So, whereas the here it's consequential relief. Permanent injunction is consequential. Here it's says Supreme Court says it's a consequential relief. Whatever High Court did, because permanent from the view of the High Court, permanent injunction was a substantive relief. It is wrong. What it did was permanent injunction is a consequential relief. The prayer for permanent injunction, which was a consequential relief, can also said to be barred by limitation. It cannot give, as the original owner has been established now. It is true that under normal circumstances, the relief for permanent injunction sought is substantive relief, and the period of limitation would commence from the date on which the possession is sought to be disturbed, as long as the interference in possession continuous. However, in the case of the sequential relief, when the substantive relief of declaration is held to be barred by limitation, the said principle shall not be applicable. It is what it said. We'll read it again. It is true that the relief of permanent injunction sought is a substantive relief. This is what Honorable High Court held. That is a wrong view. And the period of limitation would commence from the date on which the possession is sought to be disturbed, so long as the interference in the possession continues. However, in the case of consequential relief, when the substantive relief of declaration is held to be barred by limitation, the said principle shall not be applicable. Finally, a permanent injunction must fail. This is what Honorable Court said, and the finally court concluded in that instant case, the plaintiff cannot be said to be in lawful possession of the suit land. Plaintiff means the original, not the original law. The person who purchased 1 gunta land and changed all the 6 gunta in his name is the plaintiff, original plaintiff. That is, the possession of the plaintiff is not legal or authorized by the law. The plaintiff shall not be entitled to any permanent injunction. What it said. Finally, it said that it assumed for the sake of argument that the plaintiff was in possession. It can say in that case also Once the plaintiff has lost so far as the relief of declaration, the title concerned and the defendant is held to be the true and absolute owner of the property. The true owner cannot be restrained by way of injunction. This is a very good decision. And therefore allowed the appeal and set aside the permanent injunction granted in favor of the plaintiff. That means High Court order was quashed here. So original owner has been established the rightful property title. So this is what the details about this case. Friends, please enter your valuable inputs and comments in the comment section below. Also, please like, share, and subscribe this channel. The title is Padhiyar, Prahladji, Chenaji versus Maniben, Jagmalbhai. Thank you very much, friends. ಸ್ನೇಹಿತರೆ, ಇವತ್ತಿನ ಪ್ರಕರಣ ಮಾನ್ಯ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಅಲ್ಲಿ ಏನಾಗಿರುತ್ತೆ ಅಂದ್ರೆ ಒಬ್ರು ಜಮೀನಿನ ಓನರ್ ಅಂದ್ರೆ ಜಮೀನಿನ ಮಾಲೀಕರು, ನೈಜ ಮಾಲೀಕರು ಮತ್ತೆ ಆ ಜಮೀನಿನ ಒಂದು ಭಾಗನ ಕೊಂಡುಕೊಂಡಿರೋರು ಇಬ್ರು ಮಧ್ಯೆ ಒಂದು ವ್ಯಾಜ್ಯ. ಅದರಲ್ಲಿ ಏನ್ ಹೇಳುತ್ತೆ ಅಂದ್ರೆ ಪರ್ಮನೆಂಟ್ ಇಂಜಂಕ್ಷನ್ ಅಂತ ಹೇಳ್ತೀವಿ. ಇಂಜಂಕ್ಷನ್ ಅಂತಂದ್ರೆ ಏನಂದ್ರೆ ಯಾವುದೇ ವ್ಯಕ್ತಿನ ಒಂದು ಜಾಗಕ್ಕೆ ಆ ವ್ಯಕ್ತಿ ಬರೋ ಆಗಿಲ್ಲ, ಅಲ್ಲಿಂದ ಅವ್ರನ್ನ ಆಸ್ತಿ ಮೇಲೆ ಬರೋ ಆಗಿಲ್ಲ ಅವರು ಅಂದ್ಬಿಟ್ಟು ಅವ್ರನ್ನ ತಡೆಯೋದು, ಅವರ ಒಂಥರ ಪ್ರತಿಬಂಧಕಾಜ್ಞೆ ಅಂತ ಹೇಳ್ಬೋದು ನಾವು. ಇಂಜಂಕ್ಷನ್ ಅಂದ್ರೆ ಪ್ರತಿಬಂಧಕಾಜ್ಞೆ, ಪರ್ಮನೆಂಟ್ ಇಂಜಂಕ್ಷನ್ ಅಂದ್ರೆ ಕಾಯಂ ಪ್ರತಿಬಂಧಕಾಜ್ಞೆ. ಆ ಜಮೀನಿಗೆ ಅವ್ರು ಕಾಲಿಡೋ ಆಗಿಲ್ಲ ಅಂತ ಮಾಡಿರ್ತಾರೆ. ಕಾರಣ ಏನಂದ್ರೆ ಆ ಜಮೀನಲ್ಲಿ ಮಾಲೀಕತ್ವ ಅವ್ರದ್ದಾಗಿರೋದಿಲ್ಲ. ಆತರ ಯಾರು ಇರ್ತಾರೆ ಅಲ್ಲಿ ಅಂದ್ರೆ ಕೇಸ್ ಟೈಟಲ್ ಅಂದ್ರೆ ಯಾರು ಅವ್ರದ್ದು ನೈಜ ಮಾಲೀಕರು ಅಂತ ಅವ್ರ ಹೆಸರಲ್ಲಿ ದಾಖಲೆಗಳಾಗುತ್ತೋ ಅದಾದ್ಮೇಲೆ ಬೇರೆ ಯಾರಿಗೂ ಆ ನೈಜ ಮಾಲೀಕರ ಮೇಲೆ ಕಾಯಂ ಪ್ರತಿಬಂಧಕಾಜ್ಞೆಯನ್ನ ತರುವಂತ ಅಧಿಕಾರ ಇಲ್ಲ ಅಂತ ಹೇಳಿದೆ. ಅಂದ್ರೆ ಕಾಯಂ ಪ್ರತಿಬಂಧಕಾಜ್ಞೆ ನೈಜ ಮಾಲೀಕನ ವಿರುದ್ಧ ಯಾವುದೇ ಕಾರಣಕ್ಕೂ ಇರೋ ಆಗಿಲ್ಲ, ಯಾವುದೇ ಆಸ್ತಿಗಳು ಯಾರು ತರೋ ಆಗಿಲ್ಲ. ಏನಾಗಿದೆ ಅಂದ್ರೆ ಅದೇ ಆಗಿತ್ತು. ಇಲ್ಲಿ ಪ್ರಕರಣದ ಹೆಸರು ಪದಿಯಾರ್ ಪ್ರಹ್ಲಾದ್ಜಿ ಚೆನಾಜಿ ವರ್ಸಸ್ ಮನಿಬೆನ್ ಜಗಮಲ್ಬಾಯ್. ಈ ಪ್ರಕರಣದಲ್ಲಿ ಏನಾಗಿರುತ್ತೆ ಅಂದ್ರೆ ಅವ್ರದ್ದು 6 ಕುಂಟೆ ಜಮೀನ್ ಇರ್ತದೆ. ಈ ಒಂದು ಮಹಿಳೆಯ ಗಂಡನಿಗೆ ಕೊಡ್ತದೆ ಅಭ್ಯಾಸ ಇರ್ತದೆ. ಹಾಗಾಗಿ ಮನೆ ನಡ್ಸಕ್ಕಾಗದೆ 6 ಕುಂಟೆ ಜಮೀನ್ ಇರ್ತದೆ ಅವ್ರ ಹತ್ರ. ಅದ್ರಲ್ಲಿ 1 ಕುಂಟೆ ಮಾರಿರ್ತಾರೆ. ಮಾರಿರೋದು ಯಾರಿಗಂದ್ರೆ ಪ್ರತಿವಾದಿ ಮಾರಿರ್ತಾರೆ. ಆ ವ್ಯಕ್ತಿ ಏನ್ ಮಾಡಿರ್ತಾನೆ, 6 ಕುಂಟೆ ಭಾಗದಲ್ಲಿ ಒಂದು ಕುಂಟೆ ತಗೊಂಡು 5 ಕುಂಟೆ ಈ ನೈಜ ಮಾಲೀಕರು, ಈ ಮಹಿಳೆ ಏನಿರ್ತಾರೆ ಅವ್ರ ಗಂಡನ ಹೆಸರು ಇರ್ತದೆ. ಆದ್ರೆ ಒಂದು ದುರದೃಷ್ಟವಶಾತ್ ಏನಾಯ್ತಾನೆ, ದಾಖಲೆಗಳೆಲ್ಲ ಅವನ ಹೆಸರು ಮಾಡಿಸ್ಕೊಂಡಿರ್ತಾನೆ 6 ಗುಂಟೆ. ಹಾಗಾಗಿ ಅವ್ನು ಮಾರಕ್ ಹೋದಾಗ ಈ ಮಹಿಳೆಗೆ ಗೊತ್ತಾಗುತ್ತೆ ಈಗೇನು ತಪ್ಪಾಗಿದೆ ಅಂದ್ಬಿಟ್ಟು ಅಲ್ಲಿ ತಡೆದಾಗ, ಮತ್ತೆ ಅಲ್ಲಿಗೆ ಕೋರ್ಟ್ ಮೆಟ್ಲಿ ಇರುತ್ತೆ. ಅಲ್ಲಿಗೆ ಕೆಳ ಹಂತದ ಕೋರ್ಟ್ ಹೋದಾಗ ಕೋರ್ಟ್ ಏನ್ ಹೇಳುತ್ತೆ ಅಂದ್ರೆ ಇಲ್ಲ ದಾಖಲೆಗಳೆಲ್ಲ ಅವರ ಹೆಸರೇ ಇರೋದ್ರಿಂದ ಹೌದು ಆಸ್ತಿ ಅವ್ರದೇನೆ ಅಂತ ಹೇಳುತ್ತೆ ಅಲ್ಲಿಗೆ. ಹಾಗಾಗಿ ಅವನು ಮತ್ತೆ 1976ರಿಂದ ನನ್ನ ಹೆಸರಲ್ಲೇ ಎಲ್ಲ ದಾಖಲೆ ಇದೆ ಅಂತ ಮಾಡಿಸ್ಕೊಂಡಿರ್ತಾನೆ ಅವನು. ಹಾಗಾಗಿ ಹೈಕೋರ್ಟ್ ಮೆಟ್ಲಿ ಇರುತ್ತೆ ಅದು ಪ್ರಕರಣ. ಹೈಕೋರ್ಟ್ ಮೆಟ್ಲಿ ಇರುವಾಗ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನ್ ಮಾಡ್ತಾರೆ, ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಈ ವ್ಯಕ್ತಿ ತನ್ನ ಹೆಸರಿಗೆ ಕೋಟಾ ದಾಖಲೆಗಳನ್ನ ಯಾರು ಮಾಡಿಸ್ಕೊಂಡಿರ್ತಾನೋ ಆ ಮಹಿಳೆ ವಿರುದ್ಧ, ಅವ್ರ ವಿರುದ್ಧನೇ ಕಾಯಂ ಪ್ರತಿಬಂಧಕಾಜ್ಞೆ ತಂದ್ಬಿಡ್ತಾನೆ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ. ಅಂದ್ರೆ ಈ ನಮ್ ಜಮೀನಿಗೆ ಕಾಲಿಡಾಗಿಲ್ಲ ಅಂತ. ಈ ನೊಂದ ಮಹಿಳೆ ಕಡೆಗೆ ವಿಧಿ ಇಲ್ದಂಗೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಮೆಟ್ಲಿರುವಾಗ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯ ಏನ್ ಹೇಳುತ್ತೆ ಅಂದ್ರೆ ನೋಡಿ, ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಕೊಟ್ಟಿರೋದು ಇಲ್ಲಿ ತಪ್ಪಾಗಿದೆ. ಇಲ್ಲಿ ಕಾರಣ ಏನಂದ್ರೆ ಇಲ್ಲಿ ಈ ನೈಜ ಮಾಲೀಕರು ಯಾರು ಅಂತ ತೀರ್ಮಾನ ಆಗಿದೆ. ಇಲ್ಲಿ 1 ಕುಂಟೆ ಇವ್ರ ಹತ್ರ ಇತ್ತು, ತಪ್ಪಾಗಿ ಅವ್ರ ಹೆಸರು ಹೋಗಿದೆ ಅಂತ ಆಯ್ತು. ಮಾರಿದ್ 1 ಕುಂಟೆನ ಯಾರು ತಗೊಂಡಿದ್ನೋ ಅವನ ಹೆಸರಿಗೆ 5 ಕುಂಟೆ ಉಳಿದ 5 ಕುಂಟೆನೂ ಅವನ ಹೆಸರಿಗೆ ಮಾಡ್ಕೊಂಡಿರ್ತಾನೆ. ಹಾಗಾಗಿ ಅಲ್ಲಿ ತಪ್ಪಾಗಿದೆ, ಅದು ಸರಿ ಮಾಡಿ ಈಗ ನೈಜ ಮಾಲೀಕರು ಈ ಮಹಿಳೆ ಅಂತ ಬಂದಾದ್ಮೇಲೆ ಈ ಮಹಿಳೆ ವಿರುದ್ಧವಾಗಿನೇ ನೀವು ಕಾಯಂ ಪ್ರತಿಬಂಧಕಾಜ್ಞೆ ಕೊಟ್ಟಿದ್ದು ತಪ್ಪು ಅಂತ ಹೈಕೋರ್ಟ್ ಹೇಳಿದ್ದಲ್ದೇನೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಎಷ್ಟು ಹೇಳಿದೆ, ನೈಜ ಮಾಲೀಕರು ಅಂತ ನಿರ್ಣಯ ಆದ್ಮೇಲೆ ಅವರ ವಿರುದ್ಧ ಯಾವುದೇ ಕಾರಣಕ್ಕೂ ಇನ್ನೊಬ್ಬ ವ್ಯಕ್ತಿ ತರಕಾಗೋದಿಲ್ಲ. ಜೊತೆಗೆ ಇನ್ನೊಬ್ಬ ವ್ಯಕ್ತಿ ಏನಾಗಿರ್ತಾನೆ, ಅವ್ನು ಕೋಟಾ ದಾಖಲೆ ಮಾಡ್ಕೊಂಡು ಬಂದಿರ್ತಾನೆ, ಅಲ್ಲದೆ ಅವನೇ ಅಲ್ಲಿ ಜಮೀನಿಗೆ ಅತಿಕ್ರಮ ಪ್ರವೇಶ ಮಾಡ್ದಂಗಾಯ್ತು ಇಲ್ಲಿ. ಹಾಗಾಗಿ ನೈಜ ಮಾಲೀಕರ ವಿರುದ್ಧವೇ ಯಾರು ಕಾಯಂ ಪ್ರತಿಬಂಧಕಾಜ್ಞೆ ತರಂಗಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಮಾನ್ಯ ನ್ಯಾಯಾಲಯ ನೈಜ ಮಾಲೀಕರು ಏನಿರ್ತಾರೆ ಅವರಿಗೆ ಒಂದು ಪರಿಹಾರವನ್ನ ಕೊಟ್ಟಿದೆ ಇಲ್ಲಿ. ಮತ್ತು ಅವರ ವಿರುದ್ಧ ಪ್ರತಿಬಂಧಕಾಜ್ಞೆ ಹೈಕೋರ್ಟ್ ಏನ್ ಕೊಟ್ಟಿತ್ತು ಅದನ್ನ ಇಲ್ಲಿ ವಜಾ ಮಾಡಿದೆ. ಹಾಗಾಗಿ ಇದೊಂದು ಉತ್ತಮವಾದ ಪ್ರಕರಣ. ಹಲವಾರು ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯಗಳು ಸಿವಿಲ್ ವ್ಯಾಜ್ಯಗಳಲ್ಲಿ ಯಾರು ಸುಮ್ಮನೆ ಕಾಲಹರಣ ಮಾಡ್ತಿರ್ತಾರೆ ವರ್ಷಗಟ್ಟಲೆ, ನೋಡಿ ಇದೊಂದು ಉತ್ತಮವಾದ ಬೆಳವಣಿಗೆ. ದಯವಿಟ್ಟು ಈ ಪ್ರಕರಣದ ಅಂಕಿಅಂಶಗಳನ್ನ ಪೂರ್ತಿಯಾಗಿ ಓದಿ ತಾವು ಬಿಡು ಮಾಡ್ಕೊಂಡು. ಪ್ರಕರಣದ ಹೆಸರು ಪದಿಯಾರ್ ಪ್ರಹ್ಲಾದ್ಜಿ ಚೆನಾಜಿ ವರ್ಸಸ್ ಮನಿಬೆನ್ ಜಗಮಲ್ಬಾಯ್ ಅಂತ ಇಬ್ರು. ಇದ್ರೆ ತಾವೆಲ್ಲರೂ ತಮ್ಮ ಅನಿಸಿಕೆ ಅಭಿಪ್ರಾಯಗಳನ್ನು ಕೆಳಗಿನ ಕಮೆಂಟ್ ಸೆಕ್ಷನ್ ದಾಖಲಿಸಿ. ಹಾಗೆಯೇ ಈ ಚಾನಲ್ ಎಲ್ಲರೂ ಶೇರ್ ಮಾಡಿ, ಲೈಕ್ ಮಾಡಿ ಹಾಗೂ ಸಬ್ಸ್ಕ್ರೈಬ್ ಮಾಡಿ. ಧನ್ಯವಾದಗಳು ಸ್ನೇಹಿತರೆ. ಥ್ಯಾಂಕ್ ಯು ವೆರಿ ಮಚ್ ಫ್ರೆಂಡ್ಸ್.